and thank you for joining us for a discussion on decoding estate planning and leaving your legacy. I'm Heidi Johnson Bixby. In today's agenda, we're going to define estate planning, and we're going to talk about the difference between the registration of accounts and the assets or investments, and the differences between a will and a trust. In addition, we're going to go over some distribution scenarios and some estate tax and taxation scenarios, along with how charitable giving can play into your estate plan. So what is estate planning? Most people associate it with dying, and yes, it is a process of arranging who will receive your assets when you die, but it's so much more than that. It's also the process that you use to minimize state and federal estate taxes. It's a way for you to designate health and financial affairs both while you're living and your financial affairs after you pass. Account for separate property if there's inheritance or a second marriage, and protect assets from spend down or providing care for yourself or loved ones. And it's also to care for minor children or those with special needs to protect their government benefits. And then it also can encompass your charitable goals. So what happens if you die with no estate plan? It's called intestate, and if you have no valid documents in place to indicate what your wishes are, then, and this is a motivating factor for some, the state decides. And there's a process and an order in which your assets would pass. And the first is a spouse or a state registered domestic partner. And from there, if there's no spouse or partner, then children. And if no children, then parents. And if no parents, then siblings. And it continues down the line. So sometimes this is enough of a motivating factor to realize that if you have no plan in place, that the state is going to decide. We'll talk further about the registration and how that will dictate what happens even if you don't have a will. But if you have individual assets, like a house registered in your own name and no will, then the state will decide in this order of how things will be distributed. So again, when we talk about estate planning, it is a very broad topic that encompasses a number of topics as you see on the screen. But today we're going to focus on just a few areas. The most common discussion areas are around whether you should have a will or a trust. And that is there's no right or wrong. There's a lot of factors that go into it. So we're going to talk about some of those today for you to think about your own situation and based on the information, what might be best for you. And we're also going to talk about beneficiary designations and the registration of accounts and how those coordinate with either a will or a trust. So those items on the left-hand side need to be coordinated. Additionally, we're going to talk about probate and when that comes into play. And we're going to talk about a power of attorney, both for healthcare as well as finance, and then advanced healthcare directive. Before we talk about the difference between a will and a trust, I want to stress the importance and go over what the difference is between the registration of your various assets and versus the actual asset or investment. Because the registration is important when it comes to what happens to that asset. So a registration is what helps us determine what is supposed to happen with that asset. If it's in your individual name, then you are the only person who can act on that account. There's also the option to have an individual account with what's called a TOD or transfer on death, which says it's your individual account, you're the only one who can act on it while you're living, But if you were to die, it's a form of beneficiary designation on an after-tax account. If you have a bank account, the banks often use a designation called a POD, or payable on death, but they're essentially the same thing. And then there is joint tenants, WROS, with right of survivor. So what that means is if you have 2 or 3 people, I'm just going to use 2 as an example, 2 people, joint tenants, they both own this. If one of them passes away, the survivor with right of survivorship, the survivor of that account is the one that would inherit 100% of it. And if you had 3 people initially, one person passes, the 2 remaining people would inherit the balance. So however many joint tenants with right of survivorship means they automatically inherit the balance of who has passed. Versus a tenants in common says there's, I'm going to use 2 people again, there can be many, but if you have 2 people, tenants in common say, we're in common, we own this together. But if one of us passes away, that person's share goes according to their estate planning documents, which is when we get into their registration or how they've titled that. So it doesn't automatically go to the survivor in that instance. It goes according to what their wishes are or how their registration in that tenants in common registration has been titled. We'll talk more about that. And then a trust registration says that trust document is what dictates what happens if someone's living, incapable of acting, or has passed in all instances. And then the next 3 lines are various retirement accounts. So by definition, retirement accounts have to be in the name of the person who contributed the funds to that account. So as an example, it would be Heidi's IRA or Heidi's Roth IRA. But on those accounts, there is a beneficiary designation and available. And so if there's a beneficiary listed, that is how assets would pass. And then you can get into LLCs, S Corps, C Corps, more business registrations. But the reason the registration is so important when it comes to your estate planning discussion is the registration supersedes what a will or maybe any wishes that you think you had, whatever these registrations have. So maybe you have your you have someone as a beneficiary designation on your retirement account, but that person has passed away or is someone you no longer want to benefit. If you have left their name as a beneficiary, then that is the information that the custodian is going to look to. Or same with the difference between a joint tenant or tenants in common. That is what dictates what happens to the asset. So separate from the registration is the actual asset. So you can have a checking account that is registered as an individual with the TOD, a joint tenants, a tenants in common. It can be the name of a trust. So the asset does not dictate what the registration is, but the registration does dictate what happens to that asset. So it's important to understand that assets can be registered in any number of ways, but what's important is how that asset is registered so that it passes the way you want it to. Now we're going to go through the registrations and what happens in the event that you pass away. As I was saying before, if an individual account is registered in your sole name, then if you pass away and you're the only one who had authority on that account, we have to look to a will to say what should happen to that account. And again, if you have no will, then it would pass by intestate laws. On the contrary, if you have an individual account where you're the sole person who has authority on the account while you're living, but if you die and it has a TOD or transfer on death registration, then it automatically passes to those beneficiaries or beneficiary with a death certificate, and that's what will happen to those assets. Even if your will said something different than what those beneficiary designations are, the beneficiary designation will supersede what your will says. If you instead have a joint tenant with right of survivor, the joint survivor is the one, or survivors are the ones who will receive the remaining assets. Tenants in common, you do revert back to how your share is registered. So you could have your share in a joint tenancy account registered in your individual name. So it would go back and look at the will to see how your share should be distributed. But you might have your share registered as a trust, and then it's going to look to the trust language. Or you may have your share registered to an LLC. So it depends on how your share is registered to determine what will happen with it. Similar here, if you have a trust, and not all assets can be held in trust. Retirement accounts have to be held in someone's individual name, the person who contributed to it, and then you have beneficiary designations. So coordinating your trust or will language with beneficiary designations is very important to make sure things pass accordingly. And then, as I said, retirement accounts pass by the beneficiary designation. If in some event that you did not list beneficiaries, some retirement plans have a default to say it's the spouse. Others will look to your will and it will have to go through probate. So let's give an example of the assets that someone might have and how the registration will flow depending on those assets. So let's say someone has a checking and savings account, a house, an after-tax investment account, an IRA, a Roth IRA, and some life insurance. In that instance, the assets are what they are. And what is important when it comes to your estate and understanding how assets will pass is the registration, as we've talked about. So in this instance, let's pretend this is an individual. The individual owns their checking and savings and house, and it is only in their sole name. But they also have, in this after-tax account, they've actually added the TOD beneficiary. And then, as I've said, IRAs, Roth, and life insurance as well. That has a beneficiary designation on it if it's been completed, and let's assume this person has filled that out. So their assets would pass by their will for the house and checking because it's in their individual name, and once they pass, they aren't there to dictate what happens to the account. So we would look to the will. On the after-tax account and the retirement and life insurance, though, they've included a beneficiary designation. So in those accounts, we would pass according to the beneficiary designation. And even if those designations were different than what the person had in their will. So now let's look at the scenario, same assets, but with a joint tenant with right as survivor on the house and checking. In this instance, everything would pass by the registration or beneficiary designation instead of going and looking to a will. Because with a joint tenant registration, let's assume this is a couple, one person passes, and because the survivor is the joint tenant, they have the right of survivorship, and that asset automatically passes to them with submitting a death certificate. But there's no looking to the will. The asset will pass automatically to the survivor. And then same with beneficiaries. That beneficiary designation is the priority for what will happen. Now let's look and say, what if someone has a trust? We're going to talk about the difference between a will and a trust, but if you have your checking and savings and house in the registration of a trust, and let's pretend that this person, this person or couple, it doesn't matter, has a trust, if the assets are registered to the trust, then it will pass according to the trust language. But in this instance, let's say there's an after-tax account and it has a completely different TOD beneficiary. That is who will receive that asset, even if the trust has different language. So this is why I've said the registration is what is most important, because it's what dictates what happens to the assets. So let's talk about the difference between a will and a living trust. Now keep in mind there are many types of trusts, and today we're focusing on just a living trust. Let's start with the will. Go back to the scenario with an individual and they've passed away. We look to the will because if an asset is in someone's individual name and they pass, they're no longer available to tell us what they want to have happen to that asset. So we look to the will. So a will is not valid until someone passes away. Once they pass away, assets go through probate and are part of a public record. And because it has to go through probate, it can take longer usually to distribute assets to beneficiaries. But a benefit of probate is that you are going through a process that says to the courts, here is the assets of the person who died, here were the expenses of the estate, and here are the beneficiaries according to the will and how much they should each get. So there is some accountability in going through the probate process. I know sometimes people hear probate and they think it's a scary process or an expensive process, and it's not necessarily scary, but it can be time consuming and it can be costly depending on the state. Some states are more expensive and take longer just because of their process and they're backed up. So it's not every state is created equal when it comes to probate. Wills are usually less expensive to establish than a trust, and also because someone has passed and you have to start the probate process, assets are frozen upon death, which can make it sometimes difficult because bills still need to get paid, but until you've started the probate process, you don't have access to those funds. So instead, let's look at a living trust. So a big motivator for some with a living trust is that it avoids the probate process, and therefore the distribution of the estate is private. And it's usually faster to distribute than a will because you're not going through the court system. However, that completely depends on the size of the estate and the complexity of the assets. So it is usually more expensive to initially establish a trust, and there's some logistics involved than a will. The other part that's important and attractive about a living trust is they're valid while you're living, but they're also valid while you are incapacitated, and it gives someone the ability to manage your assets for you during incapacity and then transition into estate distribution at death, because assets are not frozen at death. And another important factor is what's called ancillary probate. This is avoided with a trust. So ancillary probate is if you own assets in two different states. Let's say you have a home in Washington but a beach house on the Oregon coast, so you own assets in two states. If you have only a will, you would have to file probate in two states because you have an Oregon asset and Washington assets. So one benefit of a living trust is you avoid that need to file probate in two states because there is no probate. But what's the commonality? The commonality is under both scenarios, you get to name your beneficiaries and who will receive your assets. Both of them also are completely ability to revise until you are incapacitated or pass away. So there's a lot of revisions and changes that can be made. It also allows you to leave assets to minors and provide for guardianship whether you have a will or a trust. And a power of attorney is needed for both because there are some assets like retirement accounts that still would require a power of attorney even if you have a trust. So let's see what happens under the scenarios of while you're living, incapacitated, and at death. If you have a will, a trust, and then what happens to your retirement, and I can also say life insurance. So if you're an individual and you have a will, while you're living, you dictate all your assets. You do what you want. If you become incapacitated, your will still does not come into play. It is your power of attorney that who you've designated to make decisions for you for both financial decisions as well as healthcare decisions. Some attorneys will draft two separate POAs, one for finance and one for health. We do prefer to have those separate, but sometimes attorneys will draft those together in one document. And we like to have them separate only because some of the things in a financial power of attorney you may not want to turn into a healthcare facility. They don't really need that information. The instance of you've now passed away, the power of attorney is no longer valid once you pass, and now the will becomes valid. And the executor within that you've appointed is who carries out your wishes, and that goes through the probate process. If, on the other hand, you have a trust, you are usually the trustee of your trust. You and a spouse, you as the person who's funding the assets to the trust. And you, again, have complete control just as an individual over those assets. Usually the trust is in you or your partner's social security number, so nothing changes about your taxes. And what is a big difference between a will and a trust is that a trust provides for a successor trustee of the trust for the assets while you are living, but possibly incapacitated. So the assets that are registered to the trust, that successor trustee has the authority to act on those assets while you are living but incapacitated, but a healthcare power of attorney would additionally be needed for handling any healthcare. That's not handled through the trust. And then at death, the successor trustee continues on and carries out the trust instructions. So it's a little bit more seamless with a trust on flowing through and who acts and what their power is. With a retirement account, remember those are in someone's individual name, but if you become incapacitated, a financial power of attorney will suffice for someone to make decisions on things like maybe you have a required distribution that has to be taken, or from a tax planning standpoint, it makes sense to make a retirement distribution. That is something that is happening during incapacity, but you're still living. A financial power of attorney is needed. And then at death, the POA is no longer valid and the assets will pass according to the beneficiary designation. So a quote by Benjamin Franklin as far back as 1789 that is often quoted is, "Nothing is certain except death and taxes." And so a big question around the difference between a will and trust is often, is a will or trust avoid taxes? So does it? The answer is no. Having a trust instead of a will does not save any taxes. It is purely a planning tool for how assets can be handled during your life and during incapacity and at death. There is no tax difference between a will or a trust. So what are the taxes that we need to think about? When someone passes away, we look at their entire estate. So checking and savings, the value of their house, investments, retirement accounts, life insurance, we add all of that up. And one of the first numbers that we look at is the federal estate tax, which is over 13 million per person. So if you added that up and your estate is more than 13 million, then we'd have to look at whether you owe federal estate tax, and also planning tools to avoid that, but 13 million from an estate, a federal estate standpoint. Not every state has a state tax, but Washington and Oregon do. And so in Washington, the exemption is close to 2.2 million. This has not increased or changed since 2017 and is unlikely to in the near future. So if your taxable estate exceeds 2.193 million, we would start calculating Washington estate tax. And then in Oregon, their exemption has not changed in over 20 years and is still at $1 million. One thing to keep in mind with, it's not an estate tax, but it is a form of tax to keep in mind, that if you are over 73 and you currently have to take distributions out of your IRA accounts, those you take out over life expectancy, and there's a calculation on a minimum amount that you have to take out. And if your account goes to your spouse, then they also are allowed to take them out over life expectancy. For non-spouse beneficiaries who are 10 years young or more younger than you, they have to take out your IRA account or any pre-tax account within 10 years, which is in a sense a form of tax, because they're likely going to have a much larger distribution than you would have had to take, which speeds up the distribution amount and therefore the taxable income that they have. So let's look at someone who has a $2.1 million gross estate between a checking, a house that's in a trust, the TOD account that's worth 300, an IRA with a beneficiary designation of 500, a Roth IRA with a beneficiary designation worth 200, and life insurance worth 500,000 that has a beneficiary designation. As we've said, anything registered to the trust will pass according to the trust language, and anything with a beneficiary designation will pass according to that beneficiary designation. But let's say this person has not coordinated their designations. And so under the trust, they say 40% is going to go to person number 1, another 40% to person number 2, and 20% to charity. But the TOD account is going to a completely different person, and 100% goes to person number 3. Their IRA is also different from their trust and has 50% going to person 1 and person 2, and yet their Roth goes to a completely different person, and then their life insurance is also split 50-50 between person number 1 and 2. So in this instance, their assets are not going to pass according to their trust language fully. Only those assets that are registered to the trust are going to pass according to the trust language. The beneficiary designation supersedes everything else. So what does this look like? This looks like, according to the percentages, the 2.1 million, instead of 40% going to person 1 and 2, they end up with 35% of the estate. 14% goes to person number 3 because they got 100% of the account, and same with person number 4, and then charity receives the difference. So let's use the same estate of 2.1 million, but let's assume this individual lives in Oregon, and so they are over the Oregon estate tax limit of $1 million. In this example, we would start with the 2.1 total estate and reduce it by the exemption of $1 million, and also reduce it by the $120,000 going to charity, as that comes off the taxable estate. There are some other deductions such as attorney fees, funeral expenses, tax prep that you can also take up, but I've not illustrated that here today. So you end up in this illustration with $980,000 of a taxable estate. The first $500,000 is taxed at 10% for $50,000, and then Oregon taxes up to the next $1 million at 10.25%. So another $49,200 for total tax of $99,200. The trust beneficiaries are the ones inheriting the assets that the tax would be paid from. Beneficiaries 3 and 4 are direct beneficiaries of those accounts and do not participate in covering the taxes due. In this illustration, I said that it was split between the first and second beneficiary and not charity, though it's depending upon the fine details of how the trust is written, whether charity would participate in their share of the tax or not. So in this illustration, you would see beneficiary 1 and 2 would have roughly $50,000 of tax that would come out of their share of inheritance. Giving isn't just about making a donation, it's about making a difference. And whatever charity or community impact you want to make, charitable giving as part of your estate planning is a great tool. I think it's important to understand the charitable giving structure as of 2023. $557 billion plus were given, though 75% of that came from individuals during their life and bequests at death. So $400 billion came from individuals. The rest of it came from charitable organizations or foundations and then corporate philanthropy. But the majority of giving in the United States continues to be individuals. So what are some of the charitable giving options that you have for your estate planning? I'm only going to highlight these. I'm not going to go into depth, but during your lifetime, you certainly can use cash, use your credit card, write a check. A donor advised fund is another option that allows you to give appreciated stock or real estate into an account from which you get a tax donation for the contribution, but then you have time to give that money and grant it out to charities currently or over time. You also can gift appreciated stock or assets directly to a charity if they're set up. Some charities are too small and they aren't set up to accept a direct gift, but if they are and you know directly who you want to give to, then that's another option. A qualified charitable distribution is a tool of giving assets from your IRA to charity tax-free. However, you do need to be age 70 and a half to use qualified charitable distributions or QCDs. And then there are more intense options like a charitable remainder trust and many, many others. But these are some of the more common tools used. Also at death, you can leave a bequest. In the earlier illustration from the trust, there was 20% left to charity. So in your will or trust language, you could leave money to charity, or you can leave charity as the beneficiary of a retirement account. And a feature of that is a charity receives IRA funds tax-free. So it's a very tax efficient way in addition to reducing your taxable estate to leave money to charity. I do want to mention Ripple Impact Northwest, mentioned on this slide, their website at the bottom. They are a great resource in our community for having a further conversation around charitable giving options or discussing your own legacy. Thank you for joining us, and I hope you have learned a little bit more about the difference between a will and a trust and the importance of the registration of your investments and how those are integral to how your estate will ultimately pass to your loved ones and or to charity. This is only scratching the surface to this very complex topic, but these are the tools that are applicable to everyone and important as you start the journey of deciding how you want to leave your legacy.